A federal circuit court judge has issued a stinging rebuke to separating couples who expect the courts to decide frivolous disputes, such as the ownership of a $10 print of the Mona Lisa. Joshua Wilson expressed his displeasure after a couple appeared before his court in Melbourne with a dispute over a pile of chipped paving stones and a broken ride-on mower, among other things. Judge Wilson, who holds a doctorate in philosophy as well as a law degree, declined to intervene in the matters, saying it would be wasteful of public funds to have Commonwealth-funded judges weighing into disputes over items worth an absurdly small amount. His remarks come at a time when the family law courts are under intense pressure, dealing with upwards of 100,000 cases a year. Many of those cases involve children in dire circumstances, and facing family violence. The case before Judge Wilson, known as Noakes v. Fadden, involved a couple in their 40s who had been married for 8 years. Neither was represented in court, and each came with a huge number of documents and affidavits that Judge Wilson was then expected to sort through. The task of even locating the evidence was a formidable one, he said, adding that he had been asked to turn his mind to ownership of an outdoor heater valued at $80, and a print of Leonardo da Vinci's masterpiece Mona Lisa valued at $10. It is one thing for litigants to come to court seeking a judicial determination of disputes they are unable to resolve, Judge Wilson said. It is something altogether different for a litigant to expect a federal judge of the court that deals in approximately 100,000 cases each year to make determinations about an asset valued at $10 or $80 or even $1,000. The pressure on this court to operate in a high-volume atmosphere is exquisite. By and large, this court dispatches its business highly efficiently and supremely cost-effectively. The public interest is well served by that approach. But the public would be entitled to complain if it knew that the public purse was being consumed by a Commonwealth-funded judge being required to make determinations about assets of ridiculously small amounts. The time spent in that activity could be better spent in hearing and determining other cases. He cited an example of the couple's ride-on mower, which the wife valued at $1,200 and the husband said was worthless because it was broken. Another example was a pile of brick pavers, which the wife valued at $2,000, but the husband said were worth $400. Plus he wanted the judge to take into account that many were cracked, and that he'd expended 3 days in labor stacking them from pallets. The judge ultimately decided not to accept many of the dispute items for determination, saying simply, "It is wasteful of public funds to require a federal judge to do so." His remarks come just months after Family Court Chief Justice Diana Bryant told The Australian that her court did not have the resources it needed to protect parents and children from violence.
Source of joy, you are my source of strength, you are the creator of everything, you are the giver of life, you are my source of joy. You are my source of strength. creator of everything. You are the giver of life. Now I bow down and surrender my all to you. Now I give my praises to you. Surrender my all to you. Now I give my praises to you. You're the only one that I love. You're the only one that I need. You're the only one that I want. Surrender my all to you. Now I give my praises to you.